The federal judge ripped into Saran Wrap in bankruptcy court as he asked for us to pay LIEnette. You think that was gonna happen, George?
For damages? What damages? If anything, she's caused us damages.
Another huge win for Team What the Hells in bankruptcy court
Well,
today.
I kind of saw that coming, though.
Oh, you must have that Arabic intuition.
I do. I'm very intuitive at times. Although I do have my times where I'm not intuitive at all.
Well, these things happen. Well, we were scheduled for bankruptcy court today. Two things were going to be heard. Number one, we filed a motion against them stating that they were exempted under homesteading. Now, homesteading may mean a lot of different things to a lot of different people, right?
Right.
But basically, in a nutshell, in the state of Florida, and it's not like this in all states, homesteading, basically you say, this is my piece of property, I get a lower tax rate because this is where I reside. Now, here's the funny part, okay? Because LIEnette and CROOK live in Otter Creek, stalked us to Otter Creek.
Yes.
You know, this tiny little town that is incorporated.
Correct.
Because they live in a town of Otter Creek that's incorporated, where they followed us and stalked us, homestead exemption will only apply to half an acre. That's it. Because they're in an incorporated Otter Creek. Now, this is the funniest part.
Okay. Let's do the math.
Okay, let's do the math.
Half an acre.
Half an acre out of 1.66 acres that they purchased across the street from us. So 1.16 acres is 100% going up for auction in the federal bankruptcy court. Now, only half an acre would actually be able to be exempt from that full auction, as they claim Florida homestead.
Correct.
Major problem here for them is they live in Otter Creek that's incorporated, which constrains it to half acre. You remember when we were like, just unincorporate Otter Creek?
Yes, and she was against it.
She was like, no!
We don't want the county to take over. No!
Isn't it ironic? If Otter Creek would have unincorporated, she could have homesteaded all of it. 1.66 acres. Now, you heard us stop talking about unincorporating Otter Creek once this all came up because we already knew where we were headed. So, the funniest part is if she would have pushed to unincorporate Otter Creek, she potentially could have homesteaded it all. But now she's guaranteed to lose 1.16 acres. And she's trying to fight for half an acre, saying that she's exempt under the Homestead Act. But we filed to say, no, we're objecting to it. She's not homesteaded. She does not have a valid building permit. Oh, wait.
Nope.
Why doesn't she have a valid building permit? Oh, fleece on the fraud. You know, that fraud raisers that she had and then didn't give her the money.
I do need to put my 2 cents in on this.
Okay. I'll take 5. You got a nickel?
Sure.
Yeah.
I'll get it to you later.
All right.
I owe you. It's no one's responsibility but LIEnette, the property owners, which is LIEnette and John CROOK, to pay their bills and have the funds to build whatever it is that they wanted to build.
Agreed.
I'm not defending Fleesa, but
Not at
it's
all.
not Fleesa's problem or responsibility to make sure that they had everything, their ducks in a row in order to proceed to build.
Lisa has way bigger problems. I mean, we're talking felony convictions, fraudulent fraud raising. Her responsibilities are criminal level. And so she's got her own issues.
So Fleesa, on the other hand, with what she did and raising funds under other people's names, whether the donor intended to send it to whoever other than her, should be held accountable for doing what she's doing.
The bankruptcy lawyers that are working for the trustee are going 100% full in on Fleesa. They are starting with her deposition first, subpoena first. She's target number 1.
Yes.
And then flowing down into LIEnette and CROOK. Well, DEUCE will be a part of all of that as well.
Yes.
So they know That's their goal number one.
She'll be the first one to be deposed.
Yep.
Before the debtor. Isn't that interesting?
Isn't that interesting? Huh? Yeah. Oh. Yep.
Okay.
Hell, all right. So let's get back into bankruptcy court.
Oh, I have one more thing to ask.
Oh, okay.
So that half acre that can be exempt in Levy County that was incorporated.
Yeah.
Does that belong to the Turtles?
Oh,
or is it the other part?
I thought it was the beautiful property, leaving a legacy for my beautiful. Who knows? By the way, I think the half acre that's going to that would be homesteaded would be the north side, which has the pile of poop, pile of garbage, Wait, hold a second. That's the south side.
When you say
isn't
poop,
that the east and the west side too? Wait.
When you say poop, can you specify? Is it the poop that LIEnette called 911 for because she found poop in the stake holes, that side, or the other side?
Well, I can assure you, it will not be the shell thing that she calls a barnuminium. Yeah. Okay.
It's that barnuminium is basically an impractical shell of a structure. It's a shell. It's a structure where she can store more garbage.
All right. So George and I know we have a meeting here in bankruptcy court. Now, obviously, I'm having pre-conversations with my lawyers. I have a specialty bankruptcy lawyer working on this as well, alongside with Randy. And we are all working with the trustee and with the trustee's lawyers as well to make sure that everything is recovered and all creditors are paid appropriately. That's a huge thing. So the very first thing I tell my lawyers is if Lisa shows up, number one, we want her on camera because this is being recorded by the federal court. And we want it! We want to see the no teeth!
Well, and it's proper court procedure for the person to turn the camera on, identify themselves.
It's legal. Have to.
So it would have been a requirement for her to attend.
And I was so looking forward to it. But alas, Fleesa did not show. I don't get it. How did a potential creditor more than Germ not show up to a bankruptcy hearing? Yeah, go figure.
Maybe she wasn't privy to that information.
Maybe not. Okay, so she doesn't even show up.
No.
As a matter of fact, neither does LIEnette. So we log in to the Zoom meeting. We are allowed to be in federal bankruptcy, the courtroom through Zoom. So we log in at 7:15. And
7:15.
Excuse me, 10:15.
Okay.
10. I don't like it. Okay.
Jeremy has his dyslexic moments.
You trying to say dyslexic was dyslexic. At 10:17, we log in. All right, 10:17, we log in. We're in the waiting room. The judge, which I thought was the judge, but it isn't. It's actually the deputy in the courtroom, lets everybody in at 10:25. And immediately you see it's being recorded. It's being recorded. And we were hoping for that. We were going to go ahead and FOIA over that. And so that's good. Now, at 10:25, I noticed something. I noticed there's no Saran Wrap. I see a ton of people. No Saran Wrap. No LIEnette. No Fleesa. Where's DEUCE? Is he out on the loose in Armenia? They're not there. 10:26. Saran Wrap does show up.
Mm-hmm. Now, the meeting was scheduled for
10:30. Yeah. 10:28. Travis, what you doing? Willis shows up. I'm like, I know that guy. Yeah. He even shows up. So he finally got court paperwork, as they've been sending him nothing but telling the federal courts they've been sending him everything. And he's not the only one. There are many others listed as creditors that they've done this to. They are lying through the lack of teeth to the court. Now, Saran Wrap does look like he's sitting in the bathroom again on a toilet.
It's been nothing but fraud on the court on her side, and it's pretty disgusting. And they didn't have Travis's legal name.
No.
Just like she's not even using her legal name on some of her court cases.
Wait till we get to Saran Wrap trying to say who he's representing and the name. It was hilarious. But we're not there yet. Don't spoil it.
Okay. So his hair was a little messy. It looked like he was out in a wind tunnel. But whatever, maybe it's the new
he's
style that's coming
sitting
in.
on a toilet, George. It could have been a wind tunnel. You got the walls all capped. I mean, if it was one of them small stalls, I like them handicap stalls. I need elbow room. Yeah.
What's it called when someone's head gets plunged into the toilet and they flush it?
That's called a royal flush.
That's what his hair looks like to me.
Yes, for the royalty. You got to have a royal flush for the royalty. There's 19 people in the waiting room, and I'm sitting there going, holy cow, there are a lot of people after LIEnette's money. DEUCE is so dumb. LIEnette and Crook have no concept of what he's done to their life. They will never, ever, they have no hope of ever recovering. They will be financially indebted to us for the rest of their pathetic lives. Then there's 20 people, and I'm going, there's more? And at 10:30, when it's supposed to start, now there's 21. Then there's 22, and it's asked to identify themselves, and they say, I'm with Chase Credit. Then there's 23. Randy is now in there, our lawyer, but our other lawyer, Dennis Levine, is in there as well. He is a specialty in bankruptcy, and he also is a specialty in acquiring land from bankruptcy. Then there's 24. And then the deputy says, the judge will be in shortly. There are 24 people on Zoom alone. No LIEnette. No LIEnette. Where's LIEnette?
I don't know.
Okay.
Not sure.
Now,
I mean, considering that she's the debtor and she's the one who filed for this frivolous bankruptcy card, she should be there. She should be in the no-no.
I know why Fleesa wasn't there. We made it very apparent in the screen. It's a no-flea zone. So the judge does show up at 10:36. And do you recall what she said, George?
She said, we are here today to discuss two motions. The first motion is for homestead exemption, and the second motion to address for damages.
Oh, yes.
And the first thing that came to mind was that LIEnette is going after DEUCE for damages.
So it's actually LIEnette coming after us with Saran Wrap for damages, because in Levy County Court for the thumbnail case, she was found guilty of a frivolous lawsuit. We were found that we are entitled, it was an entitlement here, we are entitled to financial compensation, and no amount has been set yet because of the bankruptcy court.
Yeah, the judge was very cautious and did his own research with that hearing.
That's the second motion that was being heard, which we're going to get to what the judge had to say, because the judge lit into Saran Wrap. But
she was not happy.
Before all that, she says, I apologize for the delay. There has been a nationwide outage on the court system, the system that you see. I didn't get it all down. See something, on all of their systems.
She said some abbreviation of letters.
And she said it's just been horrific the past 2 days, and it's a nationwide outage. I was sitting there thinking, oh my goodness, how are they even operating? Everything goes down, and how do we function anymore without computers? Yeah, all the systems, all the information. Wow. So Levine is there, and our hearing starts, and she asks for the counselors to, go ahead and identify themselves. And Dennis Levine says, I'm here on behalf of Jeremy Hales. Saran Wrap goes, yes, Your Honor, I'm here on behalf of, he can't remember her name. He's stuttering for like 10 seconds. Is it LIEnette? Is it LIEnette? Is it Lacey? Is it Michelle?
Alexis.
Is it Alexis? Every letter was stuttered out of his mouth. And then he finally goes, Michelle. Couldn't believe it. I'm laughing. Our camera has to be on. We're in federal court, and I'm snickering, and I'm thinking, oh, hold it back. Hold!
But can you blame him? She has so many names. How can he keep up with it?
Can't blame him. And so the judge says, we're here on the two orders. We have the objection to the claim of homestead exemption, which LIEnette...
Not orders, motions.
Okay. Motions. I may say things that are silly at times. But, there's a lot of things going on in here. We got a lot of notes written down, and we're trying to get it out as fast as possible. So thank you for the correction. So we're here on two motions. It's the objection to the exemption of homestead. So in other words, what LIEnette and CROOK are trying to do is save their property. And we have objected to that. They have no legal property because they have no legal homestead. They have no permit, they have no dwelling, and a shed does not qualify as a dwelling. As a matter of fact, in the state of Florida, living in a shed is illegal. Now, so is everything they've done to us in regards to violations of civil protection orders. Think Levy County Sheriff does anything about that? No. There are a lot of things that are illegal that nobody does anything about, but we're in federal court now. Federal court is not going to accept a tool shed as a homestead. We should put that on a shirt. Tool shed is not a homestead.
Oh, let me write that down before I forget.
Deanna's off to the side over here. I'm thinking. Yeah, okay, all right. So there, she's working on it already. Those may be coming soon. Coming soon in Otter Creek. Tool shed is not a homestead.
Yeah. Now remember, LIEnette in her bankruptcy paperwork wrote down and indicated that their camper was repoed in May of 2023.
So no camper.
And then she filed for bankruptcy July of 2023.
So nothing that they can actually live in. They have no permit for the shell of what they call a barnuminium, which is not that. I mean, LIEnette even says it's just filled with spiders and scorpions and holes, and it's unlivable. Yeah, they don't have a homestead. And again, the most hilarious part of even claiming this homestead, if she would have fought to have Otter Creek unincorporated, she could have fought for all 1.66 acres.
Well, let's go back a little bit. Had she abided by the law,
she would never even been this. Yeah, go figure. Huh? Don't break the law. You don't go to court.
We have the law on our side. She doesn't. They've been found guilty multiple times.
So the judge says, let's hear this motion first in regards to the objection of the homestead exemption. And Dennis Levine, who represents us and the specialty, he is a specialty. Most lawyers have a specialty. Law is so huge. They have a specialty where they know everything about this and this. Dennis is bankruptcy, and particularly land. And Dennis comes in and he goes, listen, this is in an incorporated town. It is more than half an acre. And we think there 100% needs to be an evidentiary hearing set. As a matter of fact, I talked to Saran Wrap last night, and he agreed that there should be an evidentiary hearing. And we, at a bare minimum, we need a half-day evidentiary hearing in Tallahassee. Remember what Saran Wrap says?
Well, I want to add on to what Levine said. Okay. He mentioned that he needs a final evidentiary hearing in order to produce discovery, and needs a rescheduled date of the final evidentiary hearing months from today, and told the judge that he believes they need about a half a day.
So I can tell you, because I already have it, in regards to discovery, there are 44 items that they are going to be requesting in regards to this hearing in discovery, all of which LIEnette will never be able to produce. I'm going to tell you what's going to happen already. They're going to lose 100%. They're already losing. It's guaranteed 1.16 acres. It's already gone. Now, how do you determine which of those acres federal court is going to seize and auction off? And what half an acre do they get to keep? Is it the little corner up front? Is it a corner in the back? You know, if I tell them, hey, I want the whole 1.116 acres in the front on the road, now they have no access to the back of the property, the half acre. Therefore, they can't cross my property to get there, and they're gone out of my life for good, which is the ultimate goal. Don't stalk us. We will make sure you're held accountable if you do. Or do they get the side that has no septic, that has no camper hookup, that has no shell thing? It just has a burn pile and a pile of poop and rotten food. Well, we're going to figure that out. The biggest thing is Saran Wrap on the toilet says, I 100% agree. We need a final evidentiary hearing and at a bare minimum half a day.
Yeah, so he did not object to the discovery for the final hearing.
Judge goes, well, that was easy. And half a day evidentiary hearing. It will be scheduled no longer than 5 months out. And she said we're gonna file a 2-month status hearing for March 31st to know where we're at in discovery. And I thought this was genius because later you're gonna find out she dug through all the information on LIEnette in the thumbnail case. She knew it all. And so she's already knows LIEnette and discovery. She's already done her homework. I was shocked. She completely and totally did her homework. Nobody gave her any of this information. And she went, 2 months, we're going to have a discovery, a status hearing to see where we're at with discovery. She already knows LIEnette's not going to send the discovery.
Correct.
And so,
because she specifically said to follow up if there's any issues with discovery. She wants a status hearing to be in the no. Because you could know or you could no.
Would you agree, George?
If there's any issues with discovery, because there is a pattern with LIEnette not turning anything in to discovery.
Except when she wants Fleesa in jail, she literally has all the receipts, all the screenshots, all the proof, which the lawyers have on Fleesa as well. I find that ironic. Can we call that karma? I got karma to my left.
Well, wouldn't she be intuitive
right.
to that and know that beforehand, though?
I got intuition to my left. I got intuition to my right.
We should do a tarot reading.
Guilty, going to jail. Guilty, going to jail.
That's the card of Fleesa behind the stand with her right hand raised like this.
Oh,
and then you see perjury.
You literally think she could raise her hand that high? I don't think so, George.
She feeds herself somehow.
Okay. So we then immediately transfer over to the second motion. Now, the second motion is Saran Wrap and LIEnette want the stay applied here in Levy County on the thumbnail case where LIEnette was found guilty and Scott Stark's estate was found guilty of filing a frivolous lawsuit, then dismissing it, and we have been found, would you call that, what's the opposite of guilty? Innocent, but no. We have been found
we won. I mean, we won.
Winners.
We're
winners.
That she brought a frivolous lawsuit against us, and we had to hire an attorney to defend us because we knew that the law was on our side and we didn't violate any laws, and the courts agreed with us.
They have to pay us. They have to pay Larry Foreman, who, by the way, is still a very close friend, even though he's not covering the case per se. Very, very close. We think Larry and Chandler are the greatest. Gonna have to pay Tat. Gonna have to pay. Geez, who else was in that? Oh, you were in that. Oh yeah. There were some others in that too, but we're talking tens of thousands of dollars. LIEnette will be liable for 50% of it, and Scott Stark will be liable for 50%. So Saran Wrap files a motion and says, no, this is illegal. This goes against the federal stay, and we want money from Jeremy Hales. That's what their motion said. Yeah. They tried to get money today in bankruptcy court. But now, obviously, she's laughing. You can see what's happened. Now, I will share this with you. The judge rips into Saran Wrap like 15, very politely, but extremely sternly, rips into him for like 15 minutes. So the judge says, all right, Saran Wrap, what's the deal here? Saran Wrap says, well, Your Honor, we feel that the motion speaks for itself. This guy is hired to argue why his motion is legally correct. His defense is the motion speaks for itself. He finally gives her a little bit more information. He says on December 17th, Levy County held a hearing and stated and found that Jeremy Hales, Martha Risk, et al., that means all the other participants, again, Larry Foreman, Tat, they are all entitled to fees. And Saran Wrap says, we believe this is fundamentally violates the stay. And we ask the court to void Levy County's decision, and we want legal fees.
For damages.
For damages. Damages, emotional, inflicted, damages.
On a lawsuit that his client brought on us that she voluntarily dismissed.
How many times now? Oh, DEUCE, you're so smart. You're so smart.
Genius.
IQ
genius.
Namaste, DEUCE. That's Saran Wrap's defense. The motion speaks for itself. Mm-hmm. We want you, this violates the stay, and we're asking the court to void Levy County, and we want fees. That was his whole defense. Judge goes, all right, Mr. Shockett or Mr. Levine, who's got something to say? Randy goes, I'm going to take this one. Randy says, hey, Judge, you just heard the exact opposite of what the law actually states. And I'm like, go, Randy! Go!
Randy was on fire.
He was on fire. Randy was on fire.
I didn't pay attention to the tie he was wearing, though. I should have.
Deanna, there's somebody out there. They're supposed to be here? Okay, all right. I'm sorry. Security is a major, major issue here. I apologize. So Randy's on fire. Completely and totally on fire. And he lays it down, and I love it. And he goes, LIEnette brought this action. She initiated the action as a debtor. Mm-hmm. And the action is against her counselor as well, Scott Stark's estate. Just because he died doesn't mean he gets out of this. Mm. When you do something illegal, your estate is now held in contempt. Now, the funniest part is his now widowed wife keeps bragging that she's going to be a millionaire this month. She is all over threads stating, you ever met a millionaire? Well, talk to me on this date. She's literally out there stating she's got all this money. Thank you. I mean, that's going to be used in court as well once we get the actual final judgment. So Jeannie Stark's going to have a rude awakening when she finds out she's 50% liable. We've already been found 100% legally entitled to the money. Mm-hmm. And after the bankruptcy, then there will be the hearing on how much money. She will not be able to wipe it away. She will not be able to set it aside with bankruptcy. It will 100% be in effect. And if she doesn't pay, there's going to be some major issues.
Well, let's not forget, Jeannie Stark is the one who took the phone call from DEUCE.
Yep.
She's the one who writes all the motions, and she was 100% in from the beginning up until the end.
So Randy goes on to state, listen, this is the law. You can't use bankruptcy as a sword and a shield. Mm-hmm. So you can't go attack Jeremy Hales with a sword and poke him and poke him and poke him and go, I'm suing you for using my image, which, by the way, I own the image. I took the pictures. They're from my public videos that I took of her in public. Therefore, I am the owner of that image. And she wants to sue me and then go, uh-oh, I'm in trouble. I'm going to be found guilty and I'm going to owe Jeremy money. Now I want to use bankruptcy as a shield so Jeremy can't sue me back. The law doesn't work that way. She initiated the lawsuit and trespass 5. The same is going to be for trespass 5. She initiated thumbnail, trespass 5. She's initiated so many ridiculous things from the most horrific legal counsel she has ever gotten. From DEUCE, from paint chips, from vomit, from lips, the hoe flunk of them all, from Fleesa. Yeah, that AI is really going to help out there. Mm-hmm. So she has been found guilty. We've been found entitled, and there will be a monetary amount. And Randy says, Judge, we ask you to completely and totally deny their motion. Jeremy doesn't owe them anything. The courts have already determined she is going to owe him money. He's entitled to the money. Okay.
Yeah. And to add to that, there was a point where her bankruptcy was dismissed because Saran Wrap failed to turn in paperwork timely. So there was a lapse. So during that lapse is when the initial filing was submitted by Randy. And that's what got us the hearing. Because her side failed. Remember.
And she can't get out of it.
She can't get out of it. So Randy made it very clear that their motion mischaracterizes what truly happened, and then talks about how his motion, the stay is not subject to an automatic stay. His motion is, or the pleading was not subject to automatic stay. The actions are against the debtor who initiated. She's the one who initiated the lawsuit. And then he
can't go out and attack people and then cry victim is basically what the law says. Now, that's what you've seen with every single one of the anti-what-the-hell's ecosystems. They've attacked us. They have broken the law. They have not remained within protected speech. Let's say this is the circle of protected speech. Your First Amendment right. It's protected speech. You get outside of it, now you're legally liable. And they cry victim, and the law goes, no, they are the victims. You have victimized Jeremy Hales and George and others. So,
and they keep weaponizing all these different ways to try and make us look like the bad guy when they're the ones who initiates everything.
So the federal judge says the Saran Wrap. Anything else you want to say?
She asked him, do you have a rebuttal?
And he goes, this claim undermines the state! As he's sitting on a toilet with, looks like he was just dunked in.
It didn't look like it a swirl.
I think he was pushing too.
Oh my gosh.
And at this point, the whole courtroom takes a drastic change as she lights into him.
Oh, this is
for
where she's on
15
fire.
minutes. 15 minutes. Now, I want to say that LIEnette has been yelled at by a lot of people. The trustee in bankruptcy, the Ohio judge, and we've witnessed all of this, depositions. This judge wasn't yelling. She was very stern and to the point. And don't you bring this garbage into my courtroom ever again. To Saran Wrap. Let me be very clear. This was all directed to Saran Wrap.
Yes.
Okay. So the very first thing she says is this motion is denied.
Denied.
Boom! That's another big win for what the Hales. So in other words, LIEnette 100% will be paying, and Scott Stark's estate will be paying ourselves, Larry Foreman, and others. Okay? Do you want to go into some of the things that the judge said to Saran Wrap?
So yeah, she did. The first thing she said is, I'm going to deny the motion for damages, and then goes into why she's denying it. And you could tell she took the time to read it and do the research prior to today's hearing.
I do want to state one thing right there. She very clearly stated that this was a complete and total waste of time in this hearing. And we should have never even been there today. And this is where she blew me away. She did so much homework. She did all of the investigation beforehand. Deanna, you can just walk behind us. Deanna's trying to be polite and not go in front of us right now. She did all the investigation beforehand. She knew everything, and we didn't even have to say anything. It was mind-boggling. I'm like, holy cow.
Yes.
Like, she's got to be so busy, and yet at the same time, this is all going, and she's just ripping it off like boom, boom. This was filed in Florida, and this, and this, and then this happened, and then this was dismissed.
Yes.
All right, you take it away from there.
These types of hearing typically have a window of 10 to 15 minutes tops. And we were in there for
Almost half hour.
Yeah. A little over half hour. And at this point, she was just so annoyed. And you could tell the frustration in her voice. And she said, the creditor is correct.
That'd be us, Randy.
That would be us. That our motion, in regards to his motion for damages, like, we're correct. And that there can be proceedings against the debtor, which is LIEnette. She verifies that, yes, because the debtor, who's LIEnette, is the one who filed and dismissed on the day of summary judgment hearing.
The eve. She said the eve of the hearing.
Summary judgment hearing.
And she went off on that. She's like...
She was even shocked that even happened. Like, why bring a suit and then the eve of dismiss it?
She was upset.
And do you want to add anything else to that?
No, go ahead.
Okay. And she even addresses that the state court, which is Judge Grobe out of Levy County, was very cautious and didn't determine an amount. He did not determine an amount.
She did her homework. She went through everything. We didn't give it to her. She came prepared. I couldn't believe it.
It was pretty impressive. I loved every minute of just hearing her. She's very educated. She's well-spoken, and she goes on to say that the state court, when we say state court, we mean Levy County, the county court, did recognize that there was a bankruptcy case. It's all in writing. Ramsaran tried to make it sound like we were sneaking and doing it behind the backs of the bankruptcy court. And recognizing that the stay does apply, I can't read that part of my writing, and then talks about how the bankruptcy, it's not the bankruptcy court's job to go behind the state court when it was already respectfully done by the creditor. They can't. What she was saying is they can't go behind the other judge's decision. It's not their job to do that. Which was the first thing I thought when I first saw that motion for damages that LIEnette and her attorney filed. I'm like, how do they have even jurisdiction over that?
She was very clear that she would never undermine what the state court did, and the state court did everything respectfully and correctly and right, and Saran Wrap did everything wrong, and she was throwing it in his face. And this is the funny part. How many times do we have to win and win and win for the antis to actually realize they're done? Everything they try and propagate out there, they try and throw out, it's propaganda. It's all lies, and it all fails, and eventually they're all going to have criminal charges.
Yeah. So then she basically tells Saran Wrap that we have the right to file that motion for sanctions, which again, an amount was not determined. It basically states that we are eligible for entitlement.
And she says that the state will determine the fees that LIEnette will be paying after the bankruptcy is over. This will go forward. This will move forward. And then she's got questions. She's like, I find it rather interesting that LIEnette Preston didn't show. Not only that, the counsel for LIEnette Preston did not show.
In Levy County that day. Yeah, she did say that. She goes, therefore, the debtor did not suffer damages because she didn't appear.
She's like, there's no even damage. She didn't even appear. The person that was damaged is the creditors, which is us. Which is us.
And then she goes on to saying that this motion was not a willful stay and denied the fees. And then this part I loved. Then she focuses her attention from Ramsaran to Levine, attorney Levine.
Our attorney.
And she tells him, next time, just file a motion for stay. We've wasted so much time.
Stay relief. So
yes,
she's so mad at Saran Wrap. She's so upset. She did all of her homework. His defense was, we believe the motion speaks for itself. This undermines the federal stay. We want money. How much are we going to get? And she looks at Dennis Levine. She goes, next time, just file the motion for stay relief, and we don't have to do all of this garbage.
Yeah. She was not happy
at
that
all.
This motion for damages
at
on
all.
Ramsaran was even entered into her court.
Now, here's the thing you have to think about. They've already upset this federal judge in bankruptcy court. She's beyond upset with Saran Wrap and LIEnette. She's in complete and total disbelief that LIEnette and her counselor didn't even show up for the thumbnail case.
Here in Levy County.
How do you think the rest of bankruptcy is going to go for LIEnette and Saran Wrap?
My guess, no bueno.
It ain't looking good in the Otter Creek hood.